She walks it loud like a thunderstorm, debunking myths with style and form. True crime, conspiracies, her game. Breaking down your wildest claims. Melissa Jade, she's got no shame. Microphone fierce like a roaring lion, unveiling secrets people been hiding. True crime queen of the digital scene. Melissa's got you hooked on her screen. She's loud, feisty, spilling tea, diving deep into mystery. Breaking down your wildest claims. Melissa Jade, she's got no shame. Murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery. Breaking down your wildest claims. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. Melissa Jade, she's got no shame. From murders to cover-ups, nothing misses. Melissa's here to share her guesses. She's got theories big and bold, no stone unturned, no case cold. She's loud, feisty, spilling tea, diving deep into mystery. Breaking down your wildest claims. Melissa Jade, she's got no shame. 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 She's loud, feisty, spilling tea, diving deep into mystery. Breaking down your wildest claims. Melissa Jade, she's got no shame.
Hello, everybody. I can't get the video to stop playing, but it will in a second. But hello, everybody. Hi, Shavani.
Hey, how are you?
I'm good. How are you?
Good, thank you.
I am so excited to be here on this lovely Tuesday, even though it kind of feels like Monday with everything being closed yesterday. But happy Tuesday, everybody. We are doing members only chat tonight because I wasn't able to get on yesterday, but here we are. So hello, everybody. Thank you all for being here. We're going to kind of jump right into things tonight. So I'm going to just start by pulling up our missing child. Our missing child of tonight's live stream is Eduardo Barraza. He has been missing since October 5th, 2025 out of Newark, New Jersey. He is 15 years old. He was last seen on the 5th. So if you or anyone who knows information on his whereabouts, please contact the Newark Police Department at 1-973-733-6277. Okay, so what we're going to go over tonight is basically like the mini hearing before the main hearing. And this is going to be in regards to the paternity case. Oh no, Shay already left. This is going to be in regards to the paternity case that Laura filed. So please keep in mind that Laura originally, like the first thing she filed in the courts was family court establishing paternity, to have a parenting plan and child support. So shortly after the last hearing that we had just finished, she went to go withdraw her petition because she claimed she had a miscarriage. Yet Clayton, and I've gotten my booty chewed up by a bunch of new people who have found my channel, I guess, through this case, starting this case, which is great. And I'm so happy to have y'all here. But I've had my booty chewed up for shortening his name to Clay instead of Clayton. and it is apparently a big no-no. So I apologize in advance if I say Clay. I'm going to do my best. And welcome, Nicole. Thank you for becoming a member. In the black span, it's a great question, PB&J. So I don't believe she photoshopped herself, because that in the next hearing where the experts will come up on the stand, the doctors, nobody mentioned, from my recollection, anything about it possibly being photoshopped. And I'm sure that they would have had the metadata at that point, versus is it possible for someone not carrying children to have like basically stomach inflammation like that and to be able to have. So I don't remember it being mentioned about Photoshop, but please, if you know, correct me if I'm wrong. And welcome, Double the Sunflowers. Thank you so much for becoming a member. Me too, Nicole Terry. Yeah, I was just saying how I've a whole bunch of new names have been in my comments, which again, welcome. You're more than welcome here. But when I say I've been chewed out for referring to him as Clay versus Clayton, I've been chewed out. And I'm like, there's, like Jonathan, you could call John, William, Will, like Will, Jessica, Jess. Like I know his name's Clayton. I just was referring to him as Clay. And when I say like, it has not been okay. And I think it's great that there's like a large community who has been following this from the beginning. And please, like help, because I told you I'm deep diving in real time. I'm not claiming to know everything about it, but the last thing you want to do is deter people away by being nasty over something so small. In my opinion, I'm not saying it to be disrespectful or anything, but it's all about how you communicate it, and to be nasty because I shortened his name down, like without thinking. That's why I put like without thinking, I would just say Clay, but yeah, very, very, so point is that if you see me say something that's wrong or you want to correct, that's fine. Like, please do. I'm learning about this in real time, but just be mindful of the way you go about it, because the last thing you'd want to do is deter people away from looking into it or bringing awareness to it. It's just, because that's like saying you're not allowed to call me Mel, you're not allowed to call me MJ, like only Melissa, like people, you could shorten a name down. I don't know. Like, it's just whatever. But welcome anyone who's new.
I think it's interesting because I've seen a lot of cases where like people involved somehow like get like dub nicknames, like maybe it's by creators or a community. It's just interesting to me.
Maybe Midnight Lace, like Midnight Lace says, maybe being such a sensitive case to many who are invested, maybe Clay feels too personal, and that's what it is. But I asked, because you guys could go back and look at the comments. You can they're like, you don't know him personally, so you can't call him Clay. And I'm like, if you can direct me, I said, if you can direct me to anywhere where he has ever said, hey, I don't want to be called Clay, my name's Clayton, absolutely, I'll respect that, but if you don't speak for him either, like the only person who should be offended if I say Clay versus Clayton is Clayton himself, but unless you can direct me to somewhere, then I don't know who you are to speak on behalf of someone and say it's not okay to shorten someone's name. I've never thought about that. When people call me Mel, I've never thought how disrespectful for you to just shorten my name. They do it all the time, or MJ, so I don't know. Point is, I didn't mean it to be disrespectful, and I encourage anyone who's new stumbling upon the channel to come and interact and just, I'm not claiming to know everything about it. I don't know all the details. I'm here to learn with the community. And so be nice. But demanding I change the title of a stream, that's not going to fly. Again, it's all about how you communicate it, but don't come in and demand, literally use the word demand you change. No, at that point, I'm just going to say F you, because that's not how you go about it.
Okay. The only time I've ever heard people really truly complain was when it came to legal matters, like in court. Like if, say, an attorney is referring by like an affectionate name versus their legal name,
Yeah.
So that's really odd, like being on social media, that's a problem. It's not the court of law.
And again, like I won't even minimize, okay, if you guys, want to correct me. That's okay. But if I'm overwhelmed by a bunch of different people, a bunch of new names I've never seen just because I randomly stumbled upon this case, who are getting defensive in my comments, and the first interaction you have is demanding I change something, that's going to be where I'm going to have an issue. Like, just be like, hey, just so you know, like, I don't think he goes by Clay. Like, I think he prefers to use Clayton. I don't even know where they're getting that from. Because again, if you have that, point me in that direction. But to make the assumption that he would be offended and then like to act as if you're offended, that's where it's like, come on, guys. But thank you, Tiffany, for 19 months. It's probably Laura.
Gosh.
I don't think so, but thank you. Hey, there's that. So there's that. Okay. So again, the hearing that we're going to be watching today is going to be the shorter hearing right before the main one. And so this is in regards to the paternity case that Laura had filed. And like I said, she sent a motion to withdraw shortly after where we last left off in the last hearing because she claimed to have a miscarriage. So Clayton and his counsel is like, no, you don't get to just withdraw. Okay. And which is very interesting, which I'm curious how often that has happened in family court, not only the unique circumstances where Laura has filed to establish paternity and get a parenting plan and financial support, essentially in her first trimester of being pregnant, but then to say no, that she can't withdraw her petition and we want to take this to trial. I'm curious how often that happens. And thank you, Little D, for 7 months. Sounds more like Raquel if she sang it. Hey, Seven Lilies. Okay, so I just wanted to glance over this right before we start this hearing. And it's not a long one. This one's 40 minutes. And then the next one, I think it's like 2.5 hours, close to 3 hours. So this is the response and objection to Laura's motion to dismiss the petition to establish paternity, legal decision-making, parenting time, and child support with prejudice. With prejudice means you cannot ever file the same action again. Hi, MK. So it says the respondent, Clayton Echard, by and through undersigned, okay, they object to Laura being able to dismiss this petition because all of a sudden now they get done. Clayton's got his what is it called? Injunction against harassment. And then all of a sudden, weeks later, you claim I had a miscarriage, I withdraw. Okay. They're like, no, you're not going to get out that easy. So.
Oh, Melissa, it's like Bachelor lore. Apparently, it hasn't been said on camera, but he does prefer to be called Clayton, and they've written articles about it.
Okay, then fair enough.
I didn't know that. Did not know.
Did you say Bachelor law?
Lore, like Bachelor lore, like people who'd follow it would know.
Oh, okay. See, I don't know
that part.
And you know what? That's totally fine. And I'll be mindful of that moving forward. It's as simple as that. It's just, like I said, if you just start to come in like more like a cult and start getting nasty over something that's an innocent, I didn't think of it like that.
Yeah.
That's where you're going to go wrong. Just, be nice. That's it.
And I'll be frank for anyone who's listening, because if they heard me say early on that I follow a lot of Bachelor stuff, I haven't followed Clayton's, like him specifically. I went to high school with Sean Lowe, who was the Bachelor. So I knew up to like a certain like extent I would follow it, and then I kind of fell off. So it's, again, this little article, Melissa, just he's never corrected it on camera. It's just apparently a thing. So now we know.
Perfect. Now we know, and I'm going to do my best. Forgive me if I do it unknowingly in the future, but I'm going to do my best to be mindful of it.
I cannot promise I won't call Laura names.
Yeah, I won't call her a piece of shit. I don't think anyone will have an issue with that. So Clayton's attorneys object to her motion to dismiss, and it says, as a motion without any proof that Laura was pregnant in the first place, and that Laura is now without a child is insufficient cause for a dismissal under Rule 29A1, which is permitting the petitioner to bring this action, seek out media attention, force respondent into court to respond to a baseless and malicious allegations in 3 different court cases before Maricopa County, to then absolve herself by suddenly claiming without any evidence that she isn't pregnant would be a gross miscarriage of justice. So Laura continues to demonstrate that she is eager to utilize the media to support her fabricated pregnancy narrative, and she will continue to claim that she was pregnant by Clayton unless this court adjudicates this matter with a finding of non-paternity. So again, this is very interesting because I'm not used to kind of going into court documents in this way, Shay, like more, we focus on criminal. Now this has turned criminal, but it's interesting to see the way the family court aspect of it. And I didn't realize, I guess you can have hearings like this and trials like this. Like, no, you don't get to just walk away scot-free. Like, you need to be able to prove you were pregnant to begin with, or you filed this petition, which was fraudulent.
Yeah. Oh, I'm glad they get to see it through, though.
Mm-hmm. So
imagine if she could just like run away from this, like she intended after her.
And that she's done before.
Mm-hmm.
So it says, Laura continues to demonstrate that she is eager to utilize the media to support her fabricated pregnancy narrative, and she will continue to claim that she was pregnant by Clayton unless this court adjudicates this matter with a finding of non-paternity. Or on or about January 2nd, 2024, Laura again contacted The Sun and stated that she firmly stands by everything, and she had a positive pregnancy test at one point that confirmed her pregnancy. The current existence of her pregnancy, as explained below, is insufficient cause for a dismissal. An adjudication that she was never pregnant, or at least that she was never pregnant by Clayton, is what the justice requires. To the extent applicable, Clayton's pending motion for leave to amend respondents' response to petition to establish paternity, notice of filing, blah, 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 are incorporated herein by reference. So Laura's motion lacks evidentiary support, misstates well-established Arizona law and policy surrounding subject matter jurisdiction, and would deprive Clayton of basic access to justice after he was involuntarily dragged into court to defend himself. Put plainly, Laura's motion cannot be granted, and to do so would be to commit grave and clear error. As and for his response and objection, Clayton provides as follows. 1, a motion stating that Laura is no longer pregnant creates evidentiary issues that must be resolved by this court, which is true because she had put out hundreds of social media posts. Laura cannot be permitted to suddenly claim without evidence that she is no longer pregnant. So Laura stated under oath without any medical evidence that she was 24 weeks pregnant on February 14th, 2024, as of November 2nd, 2023. Laura also appeared in court before Judge Gielketsis via video on October 24th with what appeared to be a pregnant stomach, which upon information and belief was actually a moon bump or a fake stomach to appear pregnant. At this time, Laura also requested Judge I'm sorry, I don't know how to pronounce that. Judge Gielketsis permit her to show the respondent her stomach to verify she was indeed pregnant, which the judge denied. And look, they got a screenshot of it here with that moon. And I want you guys to realize, like, for counsel to include in their motion, in their filing, that they never believe her to be pregnant, it was fabricated, and to wear things like moon bump, you have to be very confident in what you're saying to be true, like, because that puts your credibility and like your name on the line in regards to being an attorney. Like, they wouldn't just include baseless accusations. Yeah, a moon bump. It's not like that baby bump.
Never heard it called that. I did look up the pronunciation though of that judge because it was confusing me. It's Gielketsis.
I will still not be able to pronounce that. What is it?
Like Gielketsis. So ignore the I. Gielketsis.
I'm just going to call her G.
I think that works too. I was like, what is that? I was like, is that Greek? I don't know.
Is that Greek?
Is that Greek?
What do you mean you eat no meat? It's okay. I make them.
Oh, it's like one of my favorite movies.
Thank you, Kimmy. Miss you, MJ. I'm so glad you and Shay are covering this. Me too. And thank you so much for the super chat. So it says, if Laura is now alleging that she is no longer pregnant because of a miscarriage, a third trimester abortion, or whatever she is claiming, that her motion to dismiss curiously lacks any explanation, she must provide documentation to support the same. A miscarriage this late in an alleged pregnancy would require medical attention, if not full hospitalization, and there would be a fetal death certificate filed with vital records. So, if she otherwise disposed of the twin fetuses, a criminal investigation would be warranted to locate the remains. So Laura must provide Clayton and this court with evidence to support the existence and now non-existence of a pregnancy. So Laura's ability to provide this evidence or any evidence that complies with Rule 2 is highly dubious, and any testimony she provides should be carefully assessed, as Laura is entirely lacking in credibility. As outlined in Clayton's pending pleadings, Laura has provided no verifiable medical evidence to support her claim that she was ever pregnant. Instead, Laura offered unverifiable screenshots of appointments, positive HCG tests, a sonogram video taken from a 7-year-old YouTube video, and a demonstratively fabricated sonogram. Out of 3 fetal DNA tests, 2 have come back showing little to no fetal DNA. 1 was allegedly lost in transit. A conclusive paternity determination has now been made impossible, as petitioner refused to comply with the 4th test and ostensibly, how do I say that, Jay? Ostensibly, oh my God, that's posing difficult for me to do, has determined that stating she is no longer pregnant will allow her to evade the paternity issue and continue to perpetuate the false narrative that she was pregnant by the respondent. So the court must provide concrete and verifiable evidence to establish this critical fact, that she was pregnant by Clayton and she is no longer pregnant with Clayton's twins, to determine whether there is a cause going forward. So she has not provided any verified sonogram reports, fetal anatomy scans, any sonograms from weekly checkups, any documentation to support her statement under oath that she was 24 weeks pregnant on November 2nd, or any medical records supporting the existence of any pregnancy at all. She refuses to sign a simple HIPAA to permit the release of records from the various medical professionals she claimed under oath on the 2nd that she was being seen for her high-risk pregnancy. She now seeks to have the action she filed dismissed by claiming she is no longer pregnant, still without providing any evidence to support the same. To properly resolve this action, Laura must prove with evidence in compliance with Rule 2 that she was pregnant due to conduct on the 20th with Clayton, that she was pregnant with Clayton's twins through records held by Ravgan, which Clayton is requesting this court order be released, and 3, that she is no longer pregnant with medical records confirming the date and week of gestation that the pregnancy terminated. So Laura simply cannot evade her evidentiary burden, as Clayton is entitled to a resolution as to whether she was pregnant, whether she was pregnant with his twins, and if she was pregnant, what happened to the twin fetuses? Do you want to jump around and read number 2?
Yeah.
Oh, and thank you for becoming a member. Sorry. Thank you, 307, Mrs. Troy. Welcome.
Well, all right. This court has subject matter jurisdiction. As such, jurisdiction attaches at data filing, and subsequent acts by parties do not deprive the court of jurisdiction. Subject matter jurisdiction is the jurisdiction is established at the time of filing of the lawsuit and cannot be ousted by subsequent actions or events. And then we got some case law. It says ordinarily a court that has acquired this jurisdiction of a case cannot be deprived of the events, of course, in its proceedings. Okay. And then it says the petitioner is allegedly no longer pregnant and does not divest the court of jurisdiction. Subject matter jurisdiction attached when petitioner, she filed her verified petition to establish on August 1st, 2023, alleging that respondent was the father of her unborn twins. Nothing has occurred that would divest this court of of jurisdiction over this matter. There is one, no statute that explicitly and clearly divests the court of jurisdiction. Two, jurisdiction cannot be ousted by subsequent events. And three, Arizona law presumes retention of jurisdiction unless divestiture is clearly and unambiguously found.
I think basically, yeah, okay. So like we could just jump through it. So
yeah.
have met. Okay. So basically, parties have made good faith attempt to resolve the issues. Clayton sent Laura countless text messages reiterating his position that her petition was in bad faith and that she could not be pregnant by him after one encounter of oral sex. See text messages below. So he blocked petitioner multiple times. She created at least 13 different phone numbers, over 500 text messages, and emails threatening to take Clayton to court if he did not speak. And the Judge G affirmed that these were considered harassment. So she knew that Clayton vehemently denied that she could be pregnant. And she filed a motion to communicate and a motion for contempt denied by the court to try to force Clayton to communicate with her. But plainly, all of Clayton's attempts to resolve this issue, it went unrecognized. So look, go ahead. You want to read the text message? This is an email, and it's please check your email. Ravgen closes soon. And Ravgen is the lab to do the paternity testing that Clayton wanted to use.
Yeah, she said, I want to do the test. I need you to respond though. He said, what, you want to do the test with no stipulations? And she says, you're going to be forced by the court to meet up with me, Clayton. You might as well go along with the stipulations since it means 100% I am doing the test.
The stipulations meaning the dating contract, Shay. Like, I'm only agreeing to do this paternity test if you agree to do the dating contract with me. The court's going to force you either way.
So if we meet up once in a very public setting, like a coffee shop, you will then take the test afterwards. She responds saying, you're going to be required to do that regardless. Regardless of whether I take the paternity test now or in February. No, it is within the week's worth of stipulations and hopefully more, but absolutely no requirement in order for me to take it early. Again, it's all for you. I know who the dad is, you. So I'm doing you a favor here by offering. She says, I think the app gave me a new number, but it's redacted. If you will meet up with me, I will withdraw my request for sanctions. I also don't want to cancel my appointment because you need to be held accountable. He says, so you will meet up with me in the court with a mediator present. And her response is, that's not how it goes. The whole point of the consultation is to not waste the court's time if the issue can be resolved outside of court, which this can. So we can meet.
God.
I know.
Sorry, but this is the court. She's throwing around motions and things, trying to have him sanctioned, which means he could potentially do jail time, fines, costs, like whatever it may be. But she's using the court to force him to meet her in person. And again, she wasn't pregnant. So she just wanted to force him to be with her. That is crazy.
This is wild. I mean, after we went through did we go through Michael's stuff at the end?
I can't wait to go through Greg's too.
Yeah, I was just mind blown. Like five ways to have an abortion.
5 ways to hell, I know.
Gosh. Okay, so she says, can we just meet up and then I'll withdraw the request for sanctions? So he responds with, would you meet up in a public location like a coffee shop? Her response is, you want to talk about this in public? And he says, yes, in a setting where people and security cameras are, just so that we're both protected in the event that.
Oh my God. So petitioner Laura even went as far as to threaten to harm herself if Clayton did not communicate with her. And And then, yeah, they're trying to get Clayton is entitled to reasonable attorney fees, regardless of the source of the fees. So she had demands to date her, which is disturbing. So not only fabricate pregnancies to coerce relationships and then somehow terminate the pregnancy if they capitulate to her demands to date her, which is disturbing. So, quote, for a period of 1 week while determining the best court of action for their pregnancy, Party A and Party B will exclusively explore relationship. I have offered to give you control over the outcome of the pregnancy if we date exclusively. So she cites no laws, as none exist, that make the source of attorney's fees a defense to the court ordering fees. Okay. She has acted unreasonably, if not diabolically, by bringing this baseless petition to establish, despite knowing she was not and could not be pregnant by Clayton. And Clayton has incurred attorney's fees as a result. So she made this petition relentless, maliciously, and in bad faith. A further demonstration of her unreasonableness and for the sole purposes of attorney's fees, Laura refused to sign a stipulation to dismiss this action, as she claimed that she was stating she was never pregnant by Clayton, and it would be her committing perjury. It is frankly astounding that the petitioner is now concerned with perjury after repeatedly perjuring herself in 3 different court cases, and despite the only evidence of paternity showing little to no fetal DNA. So on December 27th, she says, this resolves, now we're in court with redacted, admitting she was never pregnant by Clayton. Her exposure at the evidentiary. Oh, okay. I think this is like the lawyers and stuff. Okay. So they're asking for a denial of Laura's motion to dismiss in its entirety, an order declaring Clayton was not the father of any children carried by Laura, or in the alternative, that Laura was not pregnant due to the conduct with Clayton on May 20th, 2023, an order compelling Rapkin Inc. to produce all records and documents related to the fetal DNA testing in this matter, an order compelling Vital Records to produce all records and documents related to a fetal death certificate for alleged twin fetuses born to Laura, schedule an evidentiary hearing, which that's the next one we're going to get to, and then respectfully submitted. Yeah, okay. So I just want to see. There's the verification. Okay, the Exhibit 4. So this is the threats, intimidation, verbal abuse, and extortion from Clayton Echard. So this is to Scottsdale Police Department from Laura, to whom it may concern, Clayton Echard is the father of my unborn twins. When I told him I was pregnant, he started writing erratic, illogical, and threatening messages. He has been clear that being a father has not been his life plan and would get in the way of his dating and professional life. This would be followed by periods of silence and him blocking me, then unblocking me to demand alternative forms of proof of pregnancy beyond the medical report I had provided him from Banner Health Urgent Care confirming it. Clayton has said he would file legal charges, criminal fraud, against me for stating that he is father of my unborn twins. Extortion is a crime. He alleges I am being untruthful. However, I have even done a test in front of him that he purchased himself. It was positive. In addition, he has provided with medical test results, recorded phone calls with doctors' offices, confirming that. What the hell was that? Hold on. Did you hear that?
I did.
Hold on. You read. I'm going to check who's breaking into my place. Hold on.
Okay. Clayton said he would file legal charges against me for stating that he's the father of my unborn twins. Extortion's a crime. He alleges I'm being untruthful. It says it was positive. In addition, he's provided with the medical test results, recorded phone calls with the doctor's office confirming the viability of the pregnancy, and screenshots of my patient portals. I also agreed to take a prenatal paternity test through a lab he found called Rabgen, but he has now gone MIA and will not allow me to schedule the first. This is really concerning. I'm sorry. Schedule the test, which would prove to him once and for all that the twins are his. I told him that I would sign a HIPAA release to allow him to speak to any of my medical providers regarding the validity of the pregnancy. I've included written correspondence with Clayton to date that clearly demonstrate his potentially violent, threatening, and intimidating behavior. I've invited him to attend a doctor's appointment on August 7th at Scottsdale Perinatal Associates with Dr. Bakul for a consultation ultrasound. His paranoia extends to the level that he believes I will have hired someone to pretend to be a doctor and who will confirm the pregnancy. He simply refuses to believe that I'm pregnant, despite seeing a test with his own eyes, and that he is the father, despite my willingness to take a paternity test. Clayton's also demanded contact information for my abusive ex who attempts to kill me. I did a TEDx talk about, and which Clayton linked to the message for his request. I have a CLETS restraining order against the man he wanted to speak to, and engaging him in communication would put me in a vulnerable position. Endangerment is a crime under ARS 13-1201. I'm very concerned about my safety, and I don't know what actions Clayton will take because he's so volatile, controlling, demeaning, and hateful. I've asked him on many occasions to reassure me that he will not hurt me or our unborn babies, and he will not respond to this just simple question. I told him I would file a police report if he didn't, and I have proof that Clayton has read and say my emails, I bet. Oh, those messages, which I'm attaching. Crimes of intimidation and threats by word or conduct are listed as a criminal offense under ARS 133601, and a domestic violence offense against a pregnant person is a felony offense under ARS 133601. For all the reasons above, I'm concerned that Clayton will cause physical harm or injury to me, and please enter all attached documents and recordings into evidence and include them with this report. Thank you.
It was I have in my shower, my stand-up shower, I have adhesive. I don't know how to to hold your shampoos and soaps on. It's adhesive, and clearly the adhesive didn't adhesive anymore because they all came bussing down.
Well, I'm glad you're okay. It's nothing.
This, oh my gosh, I haven't seen it. Interaction with your daughter to Clayton. Hi, Clayton. Have you heard from, I'm guessing it was Laura today. She was supposed to be at the barn for an early appointment with one of the horses, but the vet called me. She didn't show up. I checked my email and saw that I missed one she sent very early this morning after I went to bed. The content is private, but given the circumstances, I think it's important that you read it. So Laura to her mom. And see this must be indicative of why her mom speculating has involvement, and she could be the other person referred to in the indictment. So it says, Mom, you've always said one of your best and worst things about me is that I look to what's 10 steps ahead, then enjoy what's right in front of me. The future has always given me hope, been something I look forward to, but that's not the case anymore. You know that initially I only saw the pregnancy as holding me back in life, but with your help, I began to see it as something unexpected but not unwanted. I thought that Clayton would come around to see it in the same light, but he hasn't. So as I try to picture what my life will look like next February and beyond, I feel a sense of panic. Laura has emphasized how she feels like she couldn't raise the twins without Clayton's help. So no, I think Laura's referring to someone else. So how can I manage to raise two without Clayton's? I have pushed and pushed him to give me some sort of answer as to whether or not he will do joint custody or provide child support, but he won't get back to me. I thought that if we did paternity testing, he would step up to the plate so we could organize what the future would look like, but now he doesn't even get back to me. I don't have to read the whole thing, but do you know how insanely manipulative it is not only to send a suicide letter on her own, but then I don't know if her mom sent it herself or she claimed to be her mom in her mom's email, sending it as if this is on you, Clayton.
Mm-hmm.
I asked Clayton to explore things with me for a week or two so many times that the phrase has become cliche. It embarrassed me to ask him from day one, but it didn't feel right to never even give things a try, considering the situation we find ourselves in. He doesn't know me well enough to know I didn't seek him out and that he isn't a standout compared to my exes. He's not a billionaire like Garrett, not a famous singer like Dean, and not an Olympian like Jeremy. And if I ever, and she, in his suicide letter, in this suicide letter, she made sure to include in brackets the last names, just so Clayton can make sure to look them up. Not just the first name, because mom wouldn't know them by the first names. She made sure to include in brackets the last names. What were you going to say, though?
Well, because remember last time I was like, I want to know more about the mom. Like, I mean, you said what I was thinking. Like, I was like, is the mom manipulated, or was she writing or acting as her mom to kind of influence Clayton? I don't know.
Dude, she continues to flatter herself. It's so obvious she is writing this with intent for him to read it and take away what she wants. Huh? Clayton thinks I am an ugly girl who isn't worth his time.
Wait. Why doesn't Garrett get a laugh?
Garrett didn't?
No.
Or Garrett. Yeah, Garrett didn't get a last name.
Because Garrett doesn't exist.
Yeah, poor Garrett. Billionaire Garrett.
She wishes.
Clayton thinks I'm an ugly girl who isn't worth his time, and I know that the babies will mean I won't be worth anyone else's. Who wants to date a single mom of twins whose dads probably won't even try to take them for a weekend? I will spend years trying to explain to them why their dad couldn't try for a week to make things work with their mom when I will never understand myself. I will spend their whole lives trying to explain to them why their dad wants nothing to do with them, and I know they will feel guilty about that and have issues forever because of it. I have given Clayton outs. I have offered to have an abortion so many times because I don't want to interrupt his life. I know you've told me not to, Mom, and your reasoning isn't wrong, but I have told him so many times I would go to the press if I didn't get in communication with him to game plan the future. I have meant it each time, but chickened out every single time because I know the impact that would have on him. I hate myself for threatening him with this, but I am desperate to know what next year and beyond holds, and he refuses to give me clarity. I haven't wanted to tell you, but I have told him the 2 times I have felt borderline suicidal, which includes right now. He used the first time against me in his response to the court, saying that I had mental issues, and I'm sure he'd say that again, even though my reasoning is because of how unsure of the future I feel because of him. I have told him I would take back the complaint I submitted to the real estate board, even though I know it was justified, if he will just communicate with me. He'd rather get fired or lose his license than have a talk with me. He'd rather have the press know about the pregnancy than to speak to me. Do you know how that feels, Mom? You had Dad, you had me, and you have... I am having 2 and I have no one. I've reached out to his family and they haven't gotten back to me either. And they probably think I'm nuts too, even though, again, all I want to know is what the future holds. Clayton won't even respect the court and that he's required to communicate to me. Who wants to feel they are so worthless that they have to beg a man to give them a week of their time when they are pregnant with his children? Even when begging, he won't do it. Trust me, I won't be desperate to date him if we weren't in this situation. He has treated me like shit. But if he got to know me and I got to know him, yeah, maybe things would be different. If they weren't, then the possibility of us being together would no longer be an issue and we could focus on being the best co-parents that we could be. Doesn't Clayton realize that we could have eliminated the possibility of this months ago if he had just given it a week? Or maybe he would have surprised himself and he actually would have liked me. You know that I am a loyal and that I could have made him better, but he won't give me the chance to. That will never happen, and the eternal optimist in me has slowly become a pessimist. I've come to realize that Clayton will always view me and the pregnancy as being the worst things that happened to him. Me having the twins would be his downfall. He supposedly has a mission to help those with mental health. And although he has proven that he doesn't care about mine, I would hate to be the reason that other people don't benefit from whatever message he has to spread. Despite the fact I know he thinks I don't care about him, he's the father of my kids, and I do. I would hate it if it meant that he doesn't find the happiness he is looking for. Clearly, he can't picture a future with the twins in it, and I can't live in the present not knowing what the future with the twins holds, if that makes any sense. The anxiety I feel of not knowing what role he would play in their lives is crippling, because that would obviously impact at any time I would have gone I would have for my own hopes and dreams in the future. As a last-ditch attempt to save both of us from this, I even offered him a late-term abortion now, but he didn't respond. So now I just give up. I emailed him shortly before I wrote this, saw he read the email and didn't respond, so I know he doesn't care. His life would be better without me and the twins in it. And if he has the ability to feel any guilt for what he has done to us, I hope he does. If something happens to me, please find the nerve I didn't and share this with the world so they know I didn't suffer from any major mental health issues, but rather that I did everything I could to get Clayton to tell me what he saw the future with our kids looking like, and that he refused to tell me. At the end of the day, it really is his fault. I have called her several times. This is now mom. I have called her several times and checked her house, but she's not there. My texts are getting delivered, but she isn't responding to me or my sister or her sister. I even called the police, who said, you need to wait a much longer time before filing a missing persons report. Can you please text her? I think you would be the only one who would get her to answer if she is reachable, and we are panicking. Regardless, please email me to let me know you received this. Do you know how fucking manipulative that is? Shay.
Awful. What date was this?
Holy macaroni. This was, oh shit. This was exhibit. So when they reference the suicide letter, I remember that was exhibit 4. So the suicide letter. See response. Does it not say? It doesn't say, but I'm sure it's on that timeline.
That's what I was trying to find it on the timeline, because it was not long after that court hearing we watched that she wasn't pregnant anymore.
Shay, this is everything I despise. Thank you, Harper's Nana. We have a baby. I can't stop going down this rabbit hole. I told you guys, it is bad. It just keeps getting worse as you peel back the onion. But like, to not only be manipulative enough to hold the suicidal, but then to, like, I really want to know, did it come from her actual mom's email? Even if it did, I'm sure Laura clearly wrote this, and it's, you need to reach out to her. And she would have wrote that letter knowing she's sending it to Clayton to make him first of all, you don't know, you don't have to spend your life telling your kids why I couldn't get dad just to agree to 1 week, because at the same time, are you going to tell them if he agreed to date you for 1 week, you would agree to abort them? What the fuck is wrong with you?
Oh, for sure. So this is from July 2023.
Holy
that email.
crap, that was, oh my God. She did so much. Oh my God.
She is doing a lot here. What a shit show.
This is asking if she'll postpone the deposition. Notice of deposition. Oh my God. All right. I know, like, we're a little limited of time, so I want to get onto this hearing. But that you needed that context to know, why are they even in court? So again, the one that's following this one, no, not this. This one is February 21st, 2024 hearing. And then the next one is the trial that we're gonna, it's too much. Yeah, she's the one that just keeps on giving. I'm telling you, it's a rabbit hole. So they are all in person for this hearing. Again, you're going to have the judge in the top left when he appears. Top right is the witness stand. Bottom left is Laura, who again is the petitioner in this action, because this is the original petition in family court for child support, for a parenting plan, all that good stuff. And then you have Clayton and his attorneys in the bottom right. Yep, that's Greg Gillespie and his woman. And I say woman because I don't know if they're married, engaged. His partner probably would have been smarter. I'm not sure who is in the back far right, that female. You know what, Nina? It's a good question. Why do they have a time limit in court? I've noticed with all of the court hearings in Arizona with hers, they all have a time limit. I don't know if that's just standard in Arizona or what.
I mean, unless it's like a big case where they're blocking off like multiple days, it's natural for the court to schedule time. But the court's not knowing how much of a crapshoot it is until they get there, you know?
Right, exactly. Because you're going to see at the next one we go over the trial, like they have an allotted amount of time and they have to use it. And when it gets like that, if you only have 4 minutes left and you have a witness, you could only use the 4 minutes, which is pretty crazy.
Yeah.
All right. So here we go again. This is the one before the actual trial, but now we have the basis of what they're there for. Now at this hearing, you will see Laura is not pregnant. When I say that, she never was, but she is flat. She does not have a bump because she had claimed now to miscarry.
Yeah, so cool.
Travel sucks when you have to go to the same place.
Yeah.
It's the worst. Travel for 2
I'm
months.
like, guys,
Good morning, everyone. This is the time set in FC 2023-052-114. Appearances, please. Beginning first with Petitioner's Counsel.
Morning, Your Honor. Corey Keith appearing on behalf of Petitioner Laura Owens. Myself and client are both present, appearing in person.
Good morning to you both, and from the respondent.
Good morning, Judge. Greg Woodnick. I've got Clayton Echard with me, and my associate Isabel Rani is behind me.
Good morning to all three of you.
Oh, Isabel, I didn't even see
All right,
you.
this is the time set for status conference. If the
Yeah, I
parties
couldn't
vote
hear it.
no,
I
a
didn't know
motion
if
to
it was my
continue was
audio
filed.
again. I was about to check
Mr.
chat.
Say that again.
I didn't know if it was the audio on my end again, so I was about to check chat to see what they were saying.
Is the audio choppy for you guys, or is
I
it
couldn't
just
hear it at
sharing?
all.
What?
I couldn't hear it at all.
Oh, well, that would be a problem. Well, all they did was introduction so far. Let me know if you could hear it this time.
Woodnick, that was your motion, so I'll allow you to go.
Can you
first.
hear it?
Judge, thank you.
Mm-mm.
As the court is
No?
aware,
Can
No.
the chat hear it? No. The audio is great on your end, but you can hear it. Okay, maybe you go out and come back in, Shay. Because if it's just you, you could hear it. Okay. Damn it, man. I'm going to have to find just a new adhesive strip for my shower. In a king size bed since when? It's too small for me. My cat. Thank you, Double Sunflowers. Thank you, Neat. Thank you, everyone. This is just, you guys, this is just such a rabbit hole of a case. Like, I'm just so excited to learn more and more about it. I'm so interested in liars. I don't know. It like, cause it pisses me off. You know what it is too, when someone is this bad of a liar, and I see it in my everyday life too. I wouldn't say everyday life, but like I whether it's on YouTube or what, these liars tend to believe that they are smart enough to get you to believe them. And it is so obviously a lie. So I'm curious how their brain thinks that it's believable at all. Oh, okay, Tess. Thank you. All right, Shay, let me know if you could hear it.
zero disclosure. I don't know
Yes.
if zero is an understatement. I did speak with counsel in the hallway. He indicated that disclosure was forthcoming, maybe as soon as later this week. I'll believe it when I see it, but in any event, we are not prepared to go to trial next week on any of the remaining issues because we have nothing. I'm asking the
So this is a week away from trial. This is one of the pre-trial hearings, and that trial is intense.
court to reset the trial for 45, 60 days, whatever the court's availability is. And I'm asking the court to give us 2 hours. Petitioner invoked Rule 2. I'm stuck with it. And I intend to present a case that has foundation for evidence, and her deposition, I think, is scheduled for March 1st if she appears. As your Honor is aware, petitioner failed to appear at her first deposition setting without leave of court. So I've got to deal with that as well. So we're asking the court just to reset the trial in a couple of
Laura
months.
failed to appear at her first deposition without leave of the court. She's just no show. And I've looked, if anybody can guide me who maybe is more familiar, I have looked for Laura's deposition. I don't know if it hasn't been made publicly available. But if you happen to know if it is out there, please guide me to it. I would love to see her deposition.
And hopefully, beginning today, there's discovery compliance, and the issues of attorney's fees and sanctions, I think, have to abide trial. And I think that's where we are from our perspective.
Okay, and what time on March 1st, counsel?
Great question, Judge.
8 a.m.
8 a.m.
This morning.
My office.
All right, counsel?
Thank you, Your Honor. Your Honor, we're not opposing the motion to continue the trial. We're in agreement with the need for the continuance on the trial. I did want to address, we received a ruling regarding our motion for confidentiality this morning. There has been new evidence, threats to my client's life that were made to her on Facebook since the pleading practice regarding the motion.
Okay, so Shay, listen, we need confidentiality. We need to seal this baby up. My client has received threats to her life on Facebook. Thank you, Kimmy, for the gifted membership. Shay. It's and I think of course she's going to ask for it to be sealed, because at this point there's a following and people are invested, and she is being seen for exactly who she is, and she knows come trial. See, this is where I do debate myself a bit, because I think of Letitia and stuff, and you think she would know she's about to be screwed and everything's going to come out the same way that they're like, there's no compliance and discovery. Yes, hand over medical records that you were pregnant, yet none of that is being met, right? Or assigned HIPAA. And, but at the same time, some of these people are so cocky to where, no, they really do think it's still believable. I think she may be one of those.
Motion practice regarding that motion for confidentiality. So I did want to have the opportunity to address that with the court, assuming that the court's position still remains the same with regards to that motion. I did indicate to Mr. Woodnick we will have discovery forthcoming by the end of the week with relation to my client's pregnancy records.
Okay.
Discovery has been requested far outside of the scope of what I believe is appropriate. And so I was hoping to be able to address that with the court as well today.
Okay. All right. So we'll deal with the motion to continue first, then we'll deal with re-urging on the confidentiality and the discovery.
Understood.
Any final thoughts, Mr. Woodnick?
No, I certainly have argument on all of the confidentiality issues, and I think Your Honor ruled on it, but I'll save those for later this morning.
All right. All right. The court will grant the motion to continue. The court is going to vacate the hearing. I believe we had set for the 27th. Yes, we're going to vacate the evidentiary hearing set February 27th at 4 p.m. The court will grant the request to extend the hearing time to 2 hours. I wish I could accommodate 45 to 60 days. We're setting out much further than that, which I apologize for. But Layla, what's our first available 2-hour setting?
It's going to be June 10th, Your Honor, at 8:45.
All right, everyone check your calendar and see if that works. That would be in person again.
Confirm that was 8:45 a.m.
Yes.
I do that because I generally meet with counsel back in chambers for the first 15 minutes, but I don't want that to interrupt any testimony time. So that's why I said it then.
Understood. And that date and time works for me, Your Honor.
All right. Does that work for you, ma'am?
Yes.
Okay. Counsel?
Make it work, Judge.
Sarah, does that work for you?
Yes.
Okay. All right. So we'll set that then for June 10th at 8:45. Now, with regards to the confidential.
Oh, and just so you guys know, I'm going to be uploading all of the hearings and stuff that we've gone through. I'm going to be uploading them without commentary on the channel, just because I know some people like listening to it without commentary, and that's totally fine. So I will be uploading that to the playlist.
Re-urging of the confidentiality motion, counsel?
Your Honor, my client received Facebook messages on February 7th.
Dude, tell us.
Prefer not to read them out loud. I did show them to opposing counsel. I'm happy to show them to Your Honor as well. The conduct has just gotten increasingly more concerning from the public. There almost appears to be some sort of obsession with this case. And I think my client, rightfully so, has been nervous to participate in things like the deposition or giving up her privileged medical records because of this increasingly concerning conduct.
Oh, okay. So fuck court. I'm not going to do my deposition, and I'm not going to hand over medical records showing I was pregnant at all because of the threats. I don't even want to read, and this is nothing against counsel, but I don't even want to read the threats out loud, Your Honor, despite defense having them and despite you having them, because I am aware this is being televised, well, not necessarily televised, but recorded and eventually will be made public. That's interesting angle to go about. What do you think about that, Shay?
I don't even know right now. I am just completely befuddled by this. I'm just like wondering like why she's being so cagey. And then the whole thing with Reddit, like, is she behind the Reddit stuff? Like, is she trying to like obfuscate it?
That's
Like,
a good
this is where I want to
question.
learn more, you know?
Yeah.
When you said,
Mhm. Go ahead.
When I first like heard him talking about it, then you asked me, I'm over here going, is she like maybe the one behind the scenes, like egging it on to like avoid it?
Well, looking at how she did the emails and stuff, I'm sure she did receive threats because the internet's going to do what the internet does, but I don't trust anything from her. You are not credible. You are willing to submit fraudulent documents and records. And so at that point, it's the boy who cried wolf, right? We won't even know when something is legit and when something isn't.
Gunnar, can I approach and
Mr. Woodnick, you've seen these?
Sure.
Sure, we've seen them. But you didn't care when you were trying to
I
get
know
the
that
whole
our
world against
reply
you for
mentioned
abandoning your
voicemails and things of that nature that my client had received. Nothing directly threatening her life at that point, but obviously after the motions and reply were filed, we started to receive these messages, and so she's just concerned that things are going to continue to progress.
So what do you want to do? Not follow through with the hearing?
Yes.
And Your Honor, I'll just note as well, the person who's referenced underneath the comment that was made is my client's mother. And then I think they're trying to send over her identifying information as well. Some sort of insinuation that they know where she lives and things of that nature.
Thank you.
Uh-huh.
Okay, counsel, I'll let you come and retrieve those. Counsel response?
Judge, a couple of things. Number one, in correspondence to Mr. Keith, I asked for some of the foundational information from that. Whoever wrote what they wrote on that allegedly to Miss Owens is not my client. He didn't do it. He's not involved in it. So I appreciate that that's not the suggestion here. Whoever wrote that, it's inappropriate, but certainly not a reason to enter confidentiality orders or any sort of sealing, which I assume is going to be Mother's next in the court, that these are both public figures. And I think that the First Amendment does that.
Anyone who might be mind, please mute your phone or your tablet. Go ahead, counsel.
These are both.
Remute.
Yeah. My ADD does not do well with those noises. Thank you. Judge, these are public people. My client wasn't behind whatever that text was. Frankly, there's a level of incredulity regarding that. I'm not so sure that that text is actually real and it wasn't generated to create an argument to seal or for the confidentiality issue. I can tell Your Honor.
Oh, thank you. At this point, I can't, just like Shay said, I can't even tell you if that's a legitimate text message. She's willing to fabricate anything to get this sealed so the public doesn't know her fuckery. But here's the thing. She brought the public in. She went to the media. She went to his social media platforms to the point where then he eventually had to speak up to share his side and address it. And now it's not going in your direction, in your favor, and you want to seal it.
So, hey,
yes,
I did find, so apparently in her March 1st deposition, she admitted to falsifying a medical record, and she testified that she obtained a sonogram at
Yes.
Planned Parenthood,
Planned Parenthood. Yep.
confirmed the presence of the twins in July of 2023. Then she said she modified the image to falsely attribute it to Southwest Medical Imaging by
Yep.
altering the heading name and the date of the sonogram. And then she obtained the original sonogram anonymously at Planned Parenthood Mission Viejo on July 7th, 2023. And that Planned Parenthood does not accept patients using an alias. Patients are required to provide a government issued form of identification. So that's
Yep.
all I could really find. Like, it just keeps getting referenced, but that was like the most detail.
Because that's at the trial.
Right.
She will be questioned heavily on the fact that she altered this sonogram, but she didn't alter anything else. No, she just altered the name, the location of where she got the sonogram, because obviously when they sought out to that Planned Parenthood, there's no record of Laura Owens. Oh, well, that's because I changed the name and I went to a different location, but I used an alias, even though that's not a thing no more. You can't just use an alias and go to Planned Parenthood and have procedure or anything done without your identity. And yeah, but that's Laura. But I didn't change anything else, like the name on the sonogram or nothing. Welcome, Ronnie. Thank you for becoming a member.
And you've already, like, you've gone through her affidavit, right?
No.
Okay, I'll send it to you.
Oh, we gotta go over that.
Okay.
We gotta go over that.
Okay, I'll send it.
We're going to treat Ms. Owens records if she like them. In this case, it's now 7 months along, as we are supposed to pursuant to the rules. Just like I'm going to treat her as we're supposed to when I depose her in 2 weeks. But I certainly don't think that some random Bachelor fan maybe a really inappropriate text to Miss Owens maybe is warrant for the court to do anything other than remind everyone to act professionally, which has always been my intention.
Thank you. Final thoughts?
I agree with Mr. Woodnick in part. This isn't his client, in my opinion, that's making these statements. However, when you couple the statements that are being made that appear to be getting progressively worse with the instances that were cited in our reply, the civil welfare checks that were sent to her home, the calls to her personal cell phone, when you couple all of these things together and look at the fact that they're getting progressively worse, and my client is now being essentially compelled to produce documents pertaining to her medical history, we don't anticipate this getting better, Your Honor. And my concern is that as this continues to get worse, we start to continue to talk about the safety of the parties involved. I understand that we're talking about public figures to an extent. My client has taken a significant step back. I don't know if, in my opinion, I would classify her as a public figure. She maybe is making statements now to try to defend herself and defend her name. But, Your Honor, my concern is that if this continues to worsen, and like I stated in my response, we don't know what state it's going to get to. We also have witnesses that are afraid to come forward to testify.
Sorry, hold on. It's Laura's fictional characters. Chase J. Jones, an HBU student who wrote an article trying to cancel Clayton for a TikTok using a song with the N-word, later busted by Dave Neal's audience of being Laura. Wow, it just keeps getting better. Oh my gosh.
Testify on my client's behalf because they're afraid of what's happening to my client and her family. And so for those reasons, we believe that it's worth at least requesting that the court reconsider the ruling on the motion for confidentiality.
Thank you. Okay, the motion to reconsider is denied. However, we will have the minute entry reflect that Arizona, it's ARS
Your Zoom.
Supreme Court ruling 122 is in effect, meaning all media requests must be through the Maricopa County Superior Court. There are statutory requirements that include using audio only for witnesses, fuzzying people's face out, things like that, that could give some assurances of either anonymity or whatever else may become an issue. I agree the court has absolutely no control over what people post online. It is absolutely inappropriate to threaten people generally. So the court doesn't condone that behavior. However, I don't think at this point it rises to the level of designating anything confidential. So I'm going to affirm my prior ruling on that, recognizing that there may be evidence presented at trial that will require certain exhibits be deemed confidential because of their medical nature or addresses or other things. So the parties need to be prepared to tell me which exhibits at trial need to be designated as confidential, and I'm more than happy to do that.
Beam.
Now,
there
counsel,
go.
you also said there was an issue with discovery.
Yes, Your Honor. Your Honor, my client understands the court likely in need, based on the recent ruling, for her to disclose things like her medical records pertaining to the pregnancy. It's been mentioned in the pleadings that opposing counsel has requested that she sign HIPAA releases. Opposing counsel has also sent requests for production of documents. Those HIPAA releases request 5 years of her medical records. Under the recent COMO ruling back in 2022, we don't believe that that's appropriate. We believe and are asking the court to order that while she should comply with requests for her medical records, it should be pertaining to the pregnancy, the only issue that's outstanding in this case. And on that note, Your Honor, there were 2 rulings on my client's previous motion to.
I will say going back 5 years is pretty standard, but I'm sure that they also want to see if there was any other pregnancy documented, since she had just been claimed to have been pregnant with Greg Gillespie's twins within a 2-year time frame of Clayton's. So that's kind of like an extra find within medical records. Not that they could just hand it right over to them, but if it comes out in court that there's no other documented pregnancies, then they could use that. Greg Gillespie can use that moving forward. Well, when she is bringing her medical history all out there, it makes it all of it. Yep.
Mm-hmm.
Dismiss, one which granted in part and left open the issues of attorney's fees and sanctions, and one which I received yesterday, which just outright denied the motion. And so I just wanted to make sure that we were still only talking about attorney's fees and sanctions. And if that is the case, I believe that my client's medical history pertaining to whether or not she was pregnant in this matter is what would be appropriate and relevant for the court to have testimony on at the upcoming trial.
Okay, before I get to you, counsel, and then obviously you'll have final thoughts to go back to that, the court's intention was to deny the motion to dismiss at this time. So that's the ruling that stands. Mr. Woodman?
Judge, I appreciate the COMO decision, and I appreciate Mr. Keith's argument. The problem
Me
is
too,
the
Harlan.
nexus of our Rule 26 issue, which is that the entire action was filed in bad faith, is not a fishing expedition under COMO. COMO was designed to stop parties from fishing expeditions. That's not it. We are looking very specifically for the mental health and medical records that would explain why someone would fabricate a pregnancy, why someone would appear in court in front of Judge Gail Ketsis with a 24-week abdomen, tell Judge Gail Ketsis that they were pregnant, and then magically the babies are gone. And I think in order for us to do that, we have a right to get the relevant mental health records and the relevant medical records. And I also remind the court that that does include the fact, as we've pled here, that there's a history of the fabricating behavior. That's actually the nexus of our Rule 26 motion. For Rule 26, which, to make a clear record, is really Arizona Family Court adopting Rule 11, Civil Rule 11, not Mental Health Rule 11, but Civil Rule 11. And it addresses the propriety of filings and the propriety of signing filings that were signed by Ms. Owens directly. And she filed them, and then she filed multiple filings after that. And every single one of those filings made claims and assertions that this court has an absolute authority over. In order for us to defend or produce an argument regarding Rule 26, we need to have those records. We will treat them appropriately. They are not going to be publicly shared for any that we have any intention of doing at this point, but it's going to be part of a very public proceeding because Ms. Owens, as recently as 4 days ago or 3 days ago, published an article about these very issues. She's she's the one who went to the Sun tabloid claiming not just that she was pregnant by Mr. Echard, Judge, but that she was pregnant with twins, and posted a visual of the twins that she was pregnant with. We have a right to all of the discovery relevant to that for the attorney's fees issue, for the sanctions issue, and for the integrity of Title 25 and the mud that Mr. Echard's been dragged through. I'm not interested in her childhood trauma. That's not relevant here. I totally agree with that. But Rule 49 does specifically say we're entitled to 5 years of back records. And I think asking them to be produced is reasonable. I also remind the court as my final comment, they've provided nothing. When I say nothing, Judge, I mean no medical records, no financial record. I mean nothing. Even the stuff that is not even controversial, like legal fees. Zero disclosure. So to come to court today and say, oh no, we want to rein in the disclosure is a little bit disingenuous. They should have been providing records along the way because that's what Rule 49 required.
Thank you, counsel. Do you recollect when the first filing was that would necessitate records back that far?
Yes, it would be 2021 February.
August 2021.
Okay. Final thoughts, counsel?
Your Honor, just to be clear, discovery has been transmitted, albeit minimally, because my client has been afraid of the backlash that would occur. My client did send Mr. Echard confirmation that she was pregnant. She sent him over the results of her blood testing. She has sent him over documents. I believe that the evidence will show that she was pregnant. I believe that that will be clear once everything is presented to the court. And I don't believe that it would be appropriate for her to have to disclose records dating back to January 1st of 2018, as the respondent is requesting, addressing her anger management, substance abuse, domestic violence, and additional things. This is a fishing expedition. This is what's covered under COMO. The difference is we don't even have this situation under COMO, Your Honor. We have a situation where there is no child. There are no best interests of a child to be considered. We have a situation where the respondent is on a fishing expedition. He's trying to pull things in and twist stories of previous incidents against my client to make it seem like she's fabricating these allegations. When the reality is, and like I said, I believe the evidence will show this, my client was pregnant. She did have a miscarriage. She's no longer pregnant. And I believe that the evidence will show that. And so for those reasons, we're asking the court not to allow this fishing expedition. They're requesting documents dating back to January of 2018. This is absolutely should be covered under COMO. And I believe that the court should actually look at this even further because, like I said, there are no best interests here to evaluate, to overrule my client's medical patient privilege. I understand that my client has an obligation to prove her pregnancy, and I think that it's in her best interest to do so as well. But to allow the respondent to go back 5 years into her domestic violence history, her substance abuse history, and obviously
because not only, again, with Greg Gillespie, you claim to have been pregnant with twins, but with Michael, which me and Chad just read their exchanges, some of their exchanges, you have to remember that TEDx talk I told you guys she did. She claimed to have been a victim of severe DV from Michael. And so that's very interesting, you know, and to be fair, no, they can't go searching for other cases, but they can, as far as how it pertains to their case. But going back 5 years is standard, though. It is standard to ask for. Thank you, Jean. Jean Alasker says, game night needs to return sometime. Have a good stream, MJ. Keep doing what you love and supporting the audience and fans who appreciate your work. Thank you so much. And yes, we need to do game night. Need to do game night. The DV history that is baseless, but is only there because she has gotten away with the same ruse with Mike Maricini. This is what happens when someone doesn't have consequences to their actions. Like, I will acknowledge she clearly was sick already, but I've, you know, like we mentioned in the last live, like I truly believe a factor in this is not only the society we live in today, but not holding someone accountable, allowing someone to get away over and over and over to the point where they are bold enough and confident enough to keep elevating their lies and taking it to this extent.
Well, you're going to be upset when you read what I sent you.
Oh, gosh. Let me tell you.
Apparently, she outraged a community because I don't know if it's proven or not. It's just alleged that she deflects some of her behavior on a new alleged autism diagnosis. And
Oh,
2024.
oh my goodness.
I know. It's like the rabbit hole. Because, I mean, she was asked in this last hearing, as she said she only had epilepsy. She
Yep.
didn't state she was on the spectrum.
No.
So that's the only reason why I'm bringing that up, because we just heard her under oath testify. This is wild. And apparently got a pretty big response from the autism community. They were
I can
really
imagine
upset.
it sets their community back, and once again, trying to even if she was on the spectrum, she would be high functioning, but you are associating shitty behavior, committing crimes, lying with autism disorder. And that's not okay. Her autism popped up after June 10th hearing on her Medium blog.
Yep.
Wow.
And I
That
sent
is
you
just
the press release from her where she talks about it. It's wild.
dude, oh my God, I'm so excited to go over all of this. The case with Mike is coming up in California court soon too. Yep, this month. We need that on the radar too. It'll be good because Mike has an amazing set of lawyers representing him, Omar Serrato and Rachel Juarez. Yeah, absolutely. I know that he has it coming up, and I'll drop the link again to this Victims of Laura Owens page, which has a direct link to his fund for anybody who's interested.
Assuming that there even is any, it's just absolutely inappropriate, and this is a fishing expedition. Thank you.
You said your client did provide limited disclosure. Did that include evidence of the miscarriage?
No, Your Honor. The miscarriage came further throughout this case, and the records that outline the miscarriage and her going to the doctor after the miscarriage have not yet been sent.
And when are well,
Your Honor, all of my client's medical records pertaining to the pregnancy will be sent to the respondent by the end of the week. I do.
By the end of the week, okay? Yeah, medical records pertaining to the miscarriage, the alleged miscarriage, and all records pertaining to pregnancy, end of this week. Okay, let's see what they'll end up with, shall we?
Have them. We were just waiting on ruling on the motion for confidentiality because we have concerns that by next week they'll be released to the public.
Gotcha, Ronnie.
how would they be released to the public counsel if they're just exchanged between counsel?
Well, Your Honor, I believe that they would also be sent to the respondent, and I can tell the court that even my own emails to opposing counsel have been, in this case, released to the public. I'm not insinuating that that is Mr. Woodnick. I understand he has an obligation to share the documents with his client, but the reality here is documents that are being transmitted, pleadings that are being filed, emails that are being sent between the parties are being released to the public in a manner of hours, not even days, certainly prior to someone's ability to pull pleadings online. Also of note, those pleadings that are being released to the public are being released in color. I believe it's common knowledge that when you go down to the courthouse and request documents, those documents come back in black and white. So it's clear to me that there's some sort of a leak to the public. That's why we filed our motion for confidentiality, and I don't believe it's appropriate for my client's records dating back to 2018 to be dragged through the public.
I think it is neat.
All right. When did the miscarriage occur, counsel?
This is the same attorney, I believe, who represented her. Because if you guys remember during that hearing, he said, we have the family court matter tomorrow. It seems like the other side of his hair had grown back at this point. But this would be the same attorney, from what I'm understanding, that would withdraw, among many, his representation of Laura and would ultimately show support for Clayton once he realized that, yeah, she was lying. She was lying. And that's got to weigh heavy. Can't be easy to always be a defense attorney handling situations like this.
She seemed to have a lot of attorneys.
Yeah, on the link of the
issues.
page that I'm dropping, it shows all of the attorneys she's had and why they withdrew or refused to represent her anymore.
Oh.
Your Honor, I'm not sure that an exact date is known.
What month?
Your Honor, I believe my client went to the doctor in mid-November, and that's when it was determined that she had had a miscarriage. We would believe that it was in the maybe months.
Okay, hold on. So when did she have a miscarriage? Do you remember when the date of the second part of the hearing that we watched was, Shay?
It was end of October.
It was, October 24th was the first part, and then November 2nd was the second part of the hearing.
Okay. Okay.
So when did she have the miscarriage? A doctor said that sometime mid-November. So conveniently within 2 weeks. Within 2 weeks of that hearing, she
Wow.
miscarried. But you will need to remember this because that doesn't stick as the date. That doesn't stick as the month. Okay.
Your Honor, I believe my client went to the doctor in mid-November, and that's when it was determined that she had had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
So
I'm
counsel,
sorry, what? I'm sorry. Did you just process what he just said, Shay?
No, sorry.
So
I was
she
zoned.
went to a doctor mid-November and it was deemed that she had a miscarriage, but she had a miscarriage a month to 2 months prior to that.
Oh.
So in the October 24th hearing, when we're watching her rub on that obnoxiously large, ever going up to her breast moon bump,
Mm-hmm.
she had already miscarried maybe a month before that, 2 months before that.
What the hell?
How, Shay? How? You were rubbing that ridiculous bump and adjusting it, yet you had already miscarried 1 to 2 months before this?
Yeah, so November 14th is when she said she had that appointment. This is wild.
Wild. So now you're claiming that bump just mysteriously at 24 weeks, yet you already miscarried 2 months. 2 months before that? How the Elmer Fudd could you even try? Yet she did. That is bold and no medical records to back this up.
I mean,
None.
does she not understand what like a miscarriage process is and what that does to a woman's body? Like,
Especially that far along.
right, with alleged twins.
Yes. You could
Huh.
clearly tell she's never been pregnant because one, she's just very uneducated about things, but two, it's such an amazing, miraculous, indescribable connection. It's an amazing ability for women to be pregnant. And for her to lie like this, it's horrendous. It's horrific. But then to say, I had already miscarried 2 months prior to me rubbing on that belly. How the hell could you even attempt that? But she knew she was fucked. And I like, again, I haven't fully figured out with the dates and everything. I'm still trying to get it organized in my brain. Like, why did she choose to say she miscarried at that time? Like, I'm sure it'll pop up as I'm watching, but how? Why? Like, why? I can't for the life of me. Yeah, when you lie like that, Samantha, it is so hard to keep track of all those lies. Yeah, Tess.
During mid-November, and that's when it was determined that she had had a miscarriage. We would believe that it was in the maybe month or 2 months leading up to that time.
so previous counsel should have disclosed that. Correct?
Well, Your Honor, I believe that the increasingly concerning nature of this case and the request for confidentiality and the request for the dismissal, I believe that given the fact that
I'm so
everything my
sorry,
client sends to respondent is being shared with the media, believe that warrants at least some degree of the court finding her actions to be.
I'm sorry, I have to pause because yes. That's why she would have chosen that date, because there is a law that says after a certain period they are viable, and when miscarried, you have to produce the fetal death certificate. You are absolutely right. That would be so. Again, look at how far these lies have to stretch, right? To claim you had already miscarried and that big bump, who knows what that was, because she cannot produce a fetal death certificate. You are 100% right.
All right. Now I'm going to look at Arizona's laws on that.
Given the fact that everything my client sends to respondent is being shared with the media, believe that that warrants at least some degree of the court finding her actions to be reasonable. She is actually receiving threats to her life, voicemails on her phone. I mean, this is concerning conduct from the public. And so we were just waiting on, same thing with the deposition. I told Mr. Woodnick we would appear for a deposition if the court ordered us to. We just
May
wanted to
20th?
have the motion to quash and a
Yeah,
motion for confidentiality
Melissa.
ruled on prior to doing so.
May 20th, I believe, was the conception date. Go ahead.
It's supposed to be that a certificate of birth is required after 20 weeks.
Right. And that if you can't, you need to show where the remains are. And if you can't, you could be criminally charged.
Wow.
Wow. That's bold. That's bold. And here's the craziest part, Shay. She had done this to at least 2 men prior, but she already was still actively in litigation with Greg Gillespie. And she still did it, which tells you again, she got away with everything. She never thought it would actually come down to what it did with Clayton. Unreal.
Because we wanted to have the court's input into if those things were necessary.
But counsel, my follow-up question to you then would be, if she had disclosed it in November, wouldn't this case have simply gone away and these issues wouldn't remain?
Well, no, Your Honor, because she did disclose the fact that she had a miscarriage. It's well documented in her pleadings. I understand that the medical record either, but my client does have a patient. She has privileges that in this case are not only being not considered or not fully considered, but it's being taken even further, and her documents are being, I have no doubt that the second we send over that disclosure statement by the end of the week, all of her records will be on Reddit. And so, Your Honor, I don't believe that. I understand where the court is coming from, and I think that had there been some sort of an agreement, we've offered for the documents to be shared between counsel. I've offered for him to come to my office and see the documents. And we've had some discussion about that. Obviously, the recent pleadings, I think, may change that from the court, but it's not us trying to hide the ball. It's us trying to make sure that my client's medical records aren't shared with the entire world.
All right, we'll have the minute at Gray reflect that no party is to disclose outside of themselves any medical or other documentation disclosed between the parties. That goes both ways. I don't want anyone releasing any exhibits, medical records, or anything else regarding.
She would have been 24 weeks along, Bible lady, at the time of the last hearing that we watched with the injunction against harassment for Clayton. And so she's claiming 2 weeks after that last part 2 of the court hearing on November 2nd, she went to a doctor. And at that doctor's appointment, she was told that she had already suffered a miscarriage unbeknownst to her 1 to 2 months prior, meaning she wasn't pregnant come that hearing any longer.
Because under oath, she stated she was 24 weeks pregnant on November 2nd.
And so she's bound by what she said under oath and what she stated that day. So she can't claim she already knew she wasn't pregnant. Yet at the same time, why didn't you disclose back in November she suffered a miscarriage? Because if you did, we wouldn't be where we are now. It's insane. It's insanity.
Releasing any exhibits, medical records, or anything else regarding the other person. And that goes both ways, and truthfully should go without saying, but I recognize it does not in this case. I am going to order that the records be disclosed dating back to August of 2020. That's 1 year prior to the first filing. I think that that's appropriate. Mr. Woodnick, do you have a release with you today that she can sign?
I've sent that.
Now, let me ask for anyone who's more familiar. August 2020, would that have included Greg Gillespie's? Because if it was 2023 and she had claimed she had gotten pregnant within 2 years, that's what Clayton's attorney had said at that hearing. So I guess it would have included yes clicker. Oh, wow. The viable pregnancy thing came out in a live stream, and she realized her error and then said she miscarried. She watches all these public live streams about herself. I heard that. No, Kelly. I've heard that. I've been told, like she watches everything and be careful covering her, which, been there, done that. But interesting, because you would think someone as deep as a hole as she is and about to go to trial and face a significant amount of time, she wouldn't be so focused. But again, that kind of emulates the exact type of person that she is, where you're more focused on your public perception, what people are thinking, and this image, this facade, this idea of you versus reality.
Yeah. So for Greg, it was end of June, early July of 2021 that she met him, and then stated that she was pregnant 2 weeks after their intimate encounter.
Now, again, they can't just openly share discovery. Like, it's not like, oh, that's a win, so you give it over to Greg. No, the discovery remains within the parties. But at the trial, what's entered into evidence can be used. And if it's stated things like there are no medical records that have been produced that prove any pregnancy has happened since August 2020 to current, that can be used like cross cases. Like you can reference that in another case. That's so interesting. It was Greg Gillespie's attorney too. Okay, so can you clarify? Because when I was doing the first stream, I think someone told me that the female that, and I don't know her name, I apologize, the female attorney who had represented Clayton for the injunction against harassment, I know that she's at his trial. So was she a part of this firm? Because I think someone had said that she had been part of Greg's counsel. So when she came in for Clayton's part 2 of his injunction against harassment, she was already familiar or whatever. So was she part of this same firm? I'm assuming so, since she's part of the trial with them.
Point. Melissa, I'm reading over this November 14th appointment and the pregnancy history. She's got 2 pregnancies listed. August 12th, 2023, 8 weeks pregnant, and January 1st, 2019, 8 weeks pregnant.
So would the January 1st, 2019 be Mike's? I guess it would be Mike's.
Yeah, I'm going to go look because I thought that was 2016.
Wait, when was the 2019? Yeah, because with Mike, his went all the way to August, September. She was having like 8 abortions.
That was 2016. And
2021
was.
Go ahead.
Yeah, it's it just says pregnancy history, August 12th, 2023, 8 weeks, January 1st, 2019, 8 weeks. Last pap smear, November 14th, 2023. Then it says the chief complaint was possible pregnancy and annual exam. The patient stated she had a positive HPT in June and then had pregnancy confirmed by Planned Parenthood. She had an initial ultrasound there, which showed a twin pregnancy. She did not have subsequent care and started bleeding a few weeks after the ultrasound, and that the patient reported she passed 2 sacs, which appeared to have been a membrane, but denies having much bleeding outside of that. She was worried about what could that mean and continued to take tests and to assess if she was pregnant. She ordered her own HCG through a Labs Now type place, which showed it was very low. Says she came to this office to find out if she was still pregnant, and the pregnancy was unplanned. The annual exam the pap smear performed today, that none of that indicated that she was pregnant.
Okay,
this
but
is
see,
bizarre.
it was June 2016 she claimed to have gotten pregnant with Mike. So if it's June 2016 with Mike and Greg's is
Yeah.
2021. Who's
I'm-
2019? And Clayton's is 2023. Who's 2019?
I don't know. I mean, I would assume that she filled out her history, you know? Unless it's the same gyno you're going to and you're not transferring your records, then you're going to fill out what your pregnancy history is, right?
Yeah, because it was June 5th, 2016.
Yeah.
Laura claimed a positive pregnancy test with Mike. Over the next
Mm.
few months, she alleged twin pregnancy, another singular pregnancy, multiple miscarriages, and several abortions. By August, she claimed to have undergone 3 surgical abortions and later said she had ovarian cancer, sending Michael numerous fabricated medical documents. So,
Yeah. And I found this on the victims page. It's under Clay, November 14th, and it says Laura attends an appointment with mom doc and takes an HCG test and confirms she's no longer pregnant. And the exhibits included the mom doc information. That's where I got it from.
see, okay, it says in late 2017, Mike and his new girlfriend unintentionally visited restaurants where Laura was present. Laura, in a fit of jealous rage, sent malicious messages with false accusations to Mike's girlfriend, claiming Mike had been physically and sexually abusive. The girlfriend saw through Owens' manipulation and supported Michael, though, anyway. But I'm curious how you got a 2019 date. Huh.
Unless there's somebody in between that never came forward. And if she was pregnant, as she says, with Michael and Greg's babies, then why aren't they listed on there?
How bizarre. We got to get an Excel spreadsheet going, Shay, for this.
Yeah, this is
one of
super
those.
bizarre, especially because you're looking at the exhibits and it's like, I mean, I would assume that like whenever I go somewhere new, like I'm filling out my own medical health history.
Oh, hell yeah. Yeah, this is one that I feel like we need an Excel spreadsheet for because there's so many dates. And the only way to really see all of the lies is to put the dates down so you could see it in a visual presentation and be like, no, that does not make sense.
Yeah, this is
Oh,
very bizarre. And that she turned that in that way. I could imagine whomever her lawyer is. I know they're not supposed to share information, but you'd be looking at that thinking, I represent the other person. Where's that pregnancy date?
Oh my gosh. See, PB&J, because I don't think she actually, I do not believe it was about, she just desperately wanted to have kids. Because, listen, if she really wanted to get pregnant, I'm sure she could have gotten pregnant. I think it was more about locking them down. That's why she was always so quick to kill them off. Horrible. This is so sick. It's so sick.
But you're right, because I think, like I asked you first, like, you know, is it a motive for money? No, she comes from a well-to-do family.
Yeah, no, she has money.
That dating contract says it all. It's either it kind of like led it to the point, like you said, like it's either she's gonna miscarry or have an abortion. Those are like her 2 plans.
Yeah.
Regardless, but it's just to get the date.
All just to be with them. And come on, like I've seen some guys be with some crazy girl. She's not a bad looking girl. Like she comes from money. She could have secured a guy, but she clearly becomes fixated. She's one of those people who become fixated. And when she becomes fixated on someone, you go for the trap, you go for the kill. And she had this same routine with them. And I just really, truly hope what happened with Greg and Mike can come into play at her trial, because I know it focuses on this family court case against Clayton. But the fact that this was not a first-time offense doing this, not saying that it's any less shitty what she's done, but like the fact that this has been numerous times, she needs to do time. Set the precedent. This is not okay.
So I found, says there's rumors that there is an ex from 2019 to 20 that chooses to remain anonymous. Interesting. That's maybe that victim.
it wasn't necessarily about kids. She tried to keep Mike with a lucrative radio job. There were fake emails coming from. That's what's interesting to me, Ronnie. I don't think it's necessarily about the kids versus it's the trap, right? I don't really think she had any interest in the kids, because if she really wanted to get pregnant any of these times, not with Clayton, but like with Mike, someone that she was in like an actual relationship with, so to speak, where the possibility to get pregnant, she probably could have, like that clearly isn't what she is looking to do. It was looking to trap them. And you could see that in their communications. Like, you're just not going to leave me after, right? I'm doing this abortion for you, but then we're going to be together, right? It's after the pregnancy she's focused on securing the relationship. It's just bizarre. It's bizarre. I've never.
Appropriate. Mr. Woodnick, do you have a release with you today that she can sign?
I've sent that.
This outlines that it would date back to 2018, so I believe we need to redline it.
That's fine.
If you'd like to adjust that, and then we can sign that and have that done today.
Okay.
You can do that now.
Judge, on the discovery issue, if I may.
Sure.
I appreciate Your Honor's ruling. Obviously, I'm assuming if there is something that comes out in those records that requires us to seek leave of the court to expand that, we can readdress that with the court. If something is in those records that imagine getting part of a medical record because of the date issue, we'd be able to come back to the court and address that if necessary.
Both parties always have that right.
Secondarily, appreciate that Your Honor's not living this case every day, but the statement of counsel was just that mother says she had a miscarriage 2 months before November. In November, the parties appeared in front of Judge Gail Ketsis, where mother had a pregnant belly and told Judge Gail Ketsis she was 100% pregnant by my client. Your Honor's not adjudicating that today, but I'm asking Your Honor to take back the protective order proceeding that was granted in my client's favor for purposes of not consolidation, to be heard concurrently for the purposes of attorney's fees and sanctions on that matter. Because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding, then I think that's sanctionable and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take not jurisdiction, but to hear that matter concurrently or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that that is the circumstance here. I certainly wasn't present. I'm saying that my client has not lied in this case. She has not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know.
Wait. I'm sorry. I have to jump back a second.
What?
That matter, because if what counsel just said is that she was not pregnant at that time and she lied to Judge Gail Ketsis in that proceeding.
So they're talking about the proceeding that we just finished, the injunction against harassment, big old baby bump one.
Then I think that's sanctionable and Your Honor could enter orders under that proceeding. So I'm asking Your Honor to take not jurisdiction, but to hear that matter concurrently or to have that file available for our upcoming evidentiary hearing.
Response?
Your Honor, I would ask the court to deny that request. Spoken to experts in this case preemptively about this trial. The reality is sometimes people have miscarriages and they don't even know that they miscarried. I'm not saying that that is the circumstance here. I certainly wasn't present. I'm saying that my client has not lied in this case. She has not intentionally lied to the court. Whether or not she was pregnant on that date, I think she could have testified that she was pregnant and she could have had a miscarriage days prior. I don't know, but I believe that the testimony in her deposition.
It went from 1 to 2 months prior. That's what Laura told you when she whispered in your ear. But now that you're actually letting that sink in, you're realizing, yeah, that's not going to make sense. So is it possible that maybe days prior? Okay, now it's to days. Yeah, there are times where people miscarrying don't know, usually very early on, though. Very early on. you can miscarry and not even know. As you're getting later in the pregnancy, that is far less likely the case.
Yeah, I thought that was like within like the first like 8 weeks. It's
Yeah.
kind of
Before sometimes you don't even know you're pregnant and then you
yeah,
miscarry very quickly.
right.
Not in a case where you have a double twin huge baby bump you're rubbing. You would know. Yeah, days. It was months. But when the judge asked him for a time frame, Laura was whispering in his ear and he was repeating it. I don't think he even had a chance to process what he was repeating based on what she was saying to him out loud. Like it probably took a second for him to be like, wait a second, what? But he already said it. Hey, MJ, I'm loving. Oh, me too. Thank you, proud grandma of 2 for our baby. Thank you.
And the testimony in her final trial and the expert testimony that will come with it will make those things clear. I believe it'd be absolutely inappropriate to throw out previous proceedings in this case based on my statement, not even my client's statement. There would need to be an evidentiary hearing in order for that to be proper.
But I think that's what he's asking. He's asking that the evidentiary hearing be wrapped into this.
And Your Honor, that's not appropriate. The evidentiary hearing has already been done. And like I said, my client's statements that were made during that hearing were true to the best of her knowledge. The reality here is sometimes women believe that they're still pregnant when they've had a miscarriage, and they don't know until they go to the doctor that their levels are no longer appropriate for a pregnant woman.
Wow.
I do believe that is what occurred in this case. Timing wise, I don't know if
Now, sorry, but notice what he just said. And it's not until you go to the doctor that you realize your levels are not appropriate with being pregnant. That's interesting wording because I never hear people refer to it like that before. But he did when it came to Laura. You know why? What you'll see is the only medical evidence she has ever provided are screenshots that have levels. And remember, it was like a crazy high level of pregnancy. We were looking at them with Mike's when she was sending Mike all of the proof of her failed abortions and whatever. She was showing very high number of HCG levels and then down to a very low level to show up the abortion really worked. Same thing in this case. So he has the idea of levels in his mind because that is the only evidence she would have even given her own attorney to prove she was and then wasn't pregnant any longer. Yeah, they were doctored.
Oh.
To the doctor that their levels are no longer appropriate for a pregnant woman. I do believe that is what occurred in this case. Timing wise, I don't know if any of us will ever be able to tell exactly when that miscarriage took place. But I do know that my client from our conversations did testify truthfully, and there were not misstatements that were made there. We're certainly not intending to change her testimony. But like I said, we have spoken to experts that have identified that sort of occurrence does sometimes happen.
Follow-up question to his comments. Counsel, are you asking that I revisit the order against harassment or just for purposes of fees and costs?
Just for purposes of fees and costs, because the order was appropriate that Judge Gelketsis entered. However, she did not order fees and costs. I would contend that if she knew what we think the evidence will show, which was that Ms. Owens just lied and said she was 24 weeks pregnant with twins, and then apparently had a miscarriage apparently 2 months earlier, that had she, if any of that is true, that had she known that was her testimony at the time, she would have ordered attorney's fees in Mr. Echard's favor. And I'd like that to be on the table at the evidentiary hearing.
Okay, so then if I'm hearing you correctly, what you're saying is the separate cause number is, you think, what delineates and prevents the court from awarding fees and costs at our evidentiary hearing in its totality.
I'm not even sure if I'm right about that. I know that the court changed the rules and required us to use different cause numbers. Otherwise, it's the same parties and it could be the same cause number. But our rules require us to have 2 separate cause numbers for the protective order proceeding, which has already been granted, and this tail end of a paternity matter. I'm just asking that Your Honor treat them as one for purposes of any attorney's fees and sanctions you may choose to order at the upcoming hearing.
All right, final thoughts on that?
Your Honor, this is a res judicata issue. The issue of attorney's fees pertaining to protective orders and injunctions against harassment have already been litigated. They've already been decided. In my opinion, to the extent Well, one, I do believe that it would inhibit, I believe it's a separate case that would inhibit this court's ability to order fees unless it were to be merged, which I don't believe is appropriate with it already being over. If there were more evidence after our trial that would warrant Mr. Woodnick believing that his client would have been entitled to fees, I believe that he would need to take recourse with that judge in that case number and seek appropriate remedies. I don't believe it's appropriate for the court to reissue something that's already been litigated in anticipation of Mr. Woodnick's assertion that there may be additional evidence that would prove his client's claim. There certainly isn't at this point. There haven't been those things proven at this point. So I'd ask the court to deny the request.
Did either party have an attorney at that hearing?
Yes, Your Honor, I believe both.
Okay. All right. So then what the court is going to do is the court is going to hear evidence and testimony as it applies to sanctions and attorney's fees and costs dating back to the filing of the petition, all pleadings filed within the Maricopa County Superior Court. So everyone's on notice to be prepared to present testimony and evidence on that. Whether I ultimately award anything as it applies to that case, I can't tell you right now because I haven't heard any evidence or testimony, but I'm not going to preclude myself from that option at this point. So we'll have the minute entry reflect it so that it's clear.
Your Honor, if there was, and I wasn't present during those proceedings, but if there was an order denying the request for attorney's fees at that time, is this court setting that order aside?
No, I definitely wouldn't be, but are both parties, I recognize that the court can take full judicial notice of the entire docket of the Maricopa County Superior Court. So I don't need your permission to go look at that case, but I do think I need your permission to go watch the hearing. Do either of you object to me going and watching the hearing?
Do it.
No, Your Honor.
Okay, so we'll have the minute entry reflect that between now
Laura,
and
I saw a little bit of a head shake there because she is going to watch you as you push that fucking baby moon bump all the way up. Oh God, see, and this is the craziest part, Shay. She didn't care. The only thing she cared about was having Clay see her with that bump. She didn't care about the repercussions, the consequences, about how serious charges she was going to face. All she cared about was, can I show Clay that I am indeed, in fact, pregnant? Because he hasn't seen me.
But yet she's so bold to quote unquote harass and corner them into trying to date her. It's just wild.
Dating contracts, suicide letters, reaching out to who they're having job opportunities with. It is crazy.
Oh.
Yes, this is the judge that ultimately will report her to the Maricopa County Prosecutor's Office for an investigation that ultimately led to the 7 indictments, felony counts, that will have her in trial come January. So hats off to this judge.
On 10th at 8:45, the court will review the order of harassment hearing. Do we know what date that occurred on?
The hearing dates, it was split in two. There was October 24th, 2023 and November 2nd, 2023.
Thank you. November 2nd, 2023. All right. So the court will review that between now and then, and that'll give me a little bit better idea of what authority, if any, I have. That just wasn't something I was willing to look at until I had the party's permission.
Thank you, Your Honor.
Okay. All right. And then with regards to Mr. Woodnick's request for the DNA testing and the vital records, is that disclosure you intend to present today or by the end of the week, as you talked about earlier?
DNA testing and the vital records, what exactly are you referring to, Your Honor?
If you look at page 14, I believe it was of his response to your motion. It requests the court issue an order compelling Ravgen Inc. to produce all records and documents related to fetal DNA testing in this matter.
Again, Ravgen is the lab that she had gotten these 3 paternal testings done through, 2 which came back little to no fetal DNA, 1 that came back lost in transit. So they want all records from Ravgen pertaining to this alleged pregnancy.
Is she sweating?
Yeah, I'm looking at her. I'm looking at her and her body communication. Her body language is interesting because it is not straight on to the judge. It is very leaned in towards her attorney, which, okay, can make sense, but she is closed off and focused in on her attorney, who, yes, is communicating for her, but she is not opening herself up to the courtroom. She is more in a prey position and blocking off her body and keeping it close to her attorney.
Ravegan Inc. to produce all records and documents related to fetal DNA testing in this matter. And subsection D was issue an order compelling Vital Records to produce all records and documents related to fetal death certificates under, and then the appropriate ARS for alleged twin fetuses born to petitioner.
Well, Your Honor, there isn't, to my knowledge, there isn't a Vital Records record or request that would be able to be produced because there wasn't one.
I'm sorry, what? Your Honor, as far as I know, those records wouldn't be able to be produced because there wasn't one. Now, it sucks. Again, as a defense attorney, he could only go off of what his own client gives to him. But what is interesting is he absolutely would have needed a HIPAA for her to sign for him. And at that point, when he requested the records and the records come back and there isn't anything that substantiated her claims, he would have, obviously he has to do his job, but it would have been very clear that there was no pregnancy on record. But he's slipping here, because you're straight up saying those records don't exist. It doesn't exist. How am I supposed to give them to defense when those records do not exist?
To my knowledge, there isn't a Vital Records record or request that would be able to be produced because there wasn't one. Regarding the DNA testing results that will be included, so what my client has would be included in our disclosure.
Okay, and when is that forthcoming, today or?
It'd be by the end of the week, Your Honor. I just have to prepare. And just for the record, I believe that Mr. Echard did participate in those with the DNA testing, so I'm not sure why he wouldn't have received those records independently as well.
And obviously, I don't know either, but I did read in your motions that one of the results was lost in the mail, so I don't know how else that was conveyed to anyone, whether it was conveyed or not, I don't know. So recognizing that it may be moot, yes, Mr. Woodnick?
If you can help us smarter than the associate whispered in my ear, Jen requested you to release the information. So if Your Honor would be inclined to, since mother's obviously now cooperating, if Your Honor would be inclined to endorse or include language in there, I'm happy to shepherd it over to Jen.
So what he's saying is, I'm not sure if it was his legal assistant or paralegal had requested to get Laura to sign a release. But now, I love that reverse psychology. Now, since mother is being cooperative and stuff, if we want to get her to sign this so we can go to Ravkin directly and get the records, let's see what she'll do.
You to release the information. So if Your Honor would be inclined to it, since mother's obviously now cooperating, if Your Honor would be inclined to endorse or include language in there, I'm happy to shepherd it over to Jen, directing them produce all records related to any DNA tests taken by or with Mr. Echard and or Miss Owens in the past 10 months.
Simple enough. You know what, sir? We don't need your records. If Miss Owens would just simply sign our release, and we'll go to Ravkin directly and get any and all records pertaining to Mr. Echard and or Mrs. Owens. But I can't imagine they're gonna do that, right? Because that's even worse than handing you over our shitty records. That'll show the actual complete set of records or lack thereof.
And or Miss Owens in the past 10 months, whatever it's been, that would be our request.
And Your Honor, for the record, I don't have an objection to that. I believe it would be an appropriate disclosure.
Okay, well, go ahead.
The other thing in our request was we had wanted mother to sign the requisite fetal death certificate, the verification, so we could get those records. I realized Mr. Keith can't testify, but is the position of mother, there will be no fetal death records because none were ever submitted. If that's the case, I'll let the issue go. I'll address it at trial, but him testifying doesn't really cut it on that issue. If not, we need confirmation from the state of Arizona that there are no fetal death certificates.
And Your Honor, that is correct. And on that note,
Ah.
and I haven't addressed this with Mr. Wood.
Ah, they're acknowledging right here, Shay, there are no fetal death records. So go ahead, you could try with the state of Arizona, but we're acknowledging we have no fetal death records to produce. So again, at the where'd you put the remains? Oh, well, I'm conveniently backtracking this miscarriage 2 months before my baby bump rubbing, and I didn't even know. So I don't have to account for where the remains are because I didn't even know I miscarried.
Ugh, it makes me sick.
Harlan, that's a great question. I guess we'll have to see what happens at trial.
But I think it might be appropriate for us to amend our initial petition just for clarity at this point and to make sure that all parties are on the same page with what's being pled. So
sorry. Oh, shit.
Thank you, Counsel.
Oh, shit. I'll find the spot. Amend. Now, please understand how big of a thing that is, because that's saying I want to amend the original petition that filed for child support, a parenting order, and a parenting plan, so you want to amend that now you're going to trial after trying to dismiss it, and there's a lot of things on the case summary back and forth. So you want to amend it to what? To include that there is no fetal death record? Hold on, I gotta get the spot back.
I think he needs some glasses. It's like intensely staring down. What does that you say? This is just mind blowing to me.
Okay, got it.
I want to see like all of her life
I know.
exposed.
I know. Perfect. Here we are.
might be appropriate for us to amend our initial petition just for clarity at this point and to make sure that all parties are on the same page with what's being pled. So I would ask the court for leave to amend our petition just so that we could make these points clear.
Amend our position.
In anticipation, although I do believe the discovery and her deposition will probably do that to an extent. I believe it's appropriate for us to make that clear.
Will her discovery, her proof, and her deposition clear the record and make everything make sense? Is that really what we think is going to happen here? I don't think so.
In the pleadings as well.
And what are those intended amendments, counsel?
Your Honor, the amendments would be just outlining the new circumstances. Obviously, her petition was filed predating any sort of miscarriage, or likely even a lot of the care surrounding the pregnancy. So it would be to make those things more clear. And also, Your Honor, I don't believe there were attorneys at the beginning of the case, so it would be to make sure that we're explicitly requesting attorney's fees as well.
Okay.
Wow.
Don't you think your motion to dismiss addressed that?
Your Honor, I think the motion to dismiss did address that in part, and it did request attorney's fees for the motion to dismiss. But if we're going to request it for the entire case, I believe amending the petition would be appropriate. I'll also note, I believe the respondent was just allowed to amend his petition a month or two prior. So I don't believe that it would prejudice anyone with us scheduling the trial out so far. I'd have no objection getting it done in a week. And if the court wants to consider our motion to dismiss a request for attorney's fees for the entirety of the case, I would be fine stipulating to that and saving the motion practice as well. And maybe Mr. Woodnick is stipulating to that.
She wants to make, if Your Honor wants to consider her claim for attorney's fees at trial, I have no issue with that. I have an issue with amending a paternity petition, which was perjured, because I don't want to be precluded from addressing the perjurous statements in the paternity petition. If they want to amend it, that's fine, but I'm not ignoring, nor do I think I have to ignore what was signed and filed with this court originally and then repeatedly prior to us coming here today. And so I don't want to lose that opportunity because mother all of a sudden realizes that stuff that she put in that petition was not truthful.
Yep.
Okay. What we'll do is we'll treat the motion to dismiss as a request for attorney's fees and a motion to dismiss. Of course, I'm not minimizing that, but we will note in the minute entry, Lamar, that both sides are seeking attorney's fees and costs. And then the leave to amend based on the argument you've presented today is denied. In the event you need leave to amend for some other reason that doesn't change the alleged facts that were presented back in August, then of course, I'm not precluding you from filing a separate motion to amend. I'm just denying your request as it's given to me today.
Understood, Your Honor, if I may. I just want to be clear. My intentions are not to change any of the facts that were originally pled,
Look at
just
her
to
nodding.
expand on the facts that were originally pled. I just want to make sure I'm clear on that.
Expand on.
I understand. All right, now with regards to disclosure, since we're set out now in June and we've got the deposition March 1st, when's an appropriate disclosure deadline? I don't know how much. It sounds like everything maybe still needs to be done, but truthfully, this is not a complex case. It shouldn't take very long.
Responses, so I guess I'll leave
I agree, Judge.
So don't know what we're getting, but if we get HIPAA responses, I guess the burden is now on us to take those HIPAA responses and go to the listed doctors that she said. I'm concerned that that's going to take some time. If she's having the HIPAA release today.
Yeah.
Do you have an inventory of what you can disclose now?
Okay, so again, a HIPAA release, great, you need a HIPAA release. But if she isn't going to give them her treating, like the providers and the facilities, that HIPAA release is essentially useless because you can't go searching around at every possible fucking facility and provider. You need to list, these are my treating physicians. I went to these providers, these facilities on these dates, so you know who to request the records from.
Okay. Okay, that's fine. So obviously March 1st is a pivotal day. Why don't we we'll set the disclosure deadline 30 days, Lamar, 30 days before trial. And that is for any disclosure beyond that deadline will be precluded. However, the parties are to complete initial disclosure no later than 45 days from today's date. So that gives you guys about 30 days after the depot. And then assuming that there may be additional depots that need to be done. Are there any questions about that schedule?
Oh, yeah.
Just my last comment, and appreciate of your time. Just so the court's aware, I have every intention of taking this HIPAA release because I sent a bunch of them originally because there's a bunch of doctors that you claim. I'm just going to reproduce it and repopulate it. Is that okay, Corey?
Yeah.
Okay. All right. We'll have the minute entry reflect that Mr. Woodnick has been provided with a amended
and provided with an open HIPAA. Basically, it's blank, but she signed it, and so he's going to reproduce and repopulate depending on the list of facility and providers that they need to send it to. Yes, Bible. And thank you, Taco Lucy, for 10 months. Oh my God, it's been too long. So glad to see you. So glad to see you too.
Signed HIPAA release, and counsel agree that he may amend the provider.
And the date as well, Your Honor, because it requested.
Yeah,
and I'm worried that they won't accept it with me crossing off the date too.
Do you want me to sign it too? It might help.
God, just get him a
I don't
new.
know how you want to do this, Judge.
Okay.
I'll
Right.
defer to you, Your Honor.
So that's
That doesn't
fine.
have any
We'll just
process.
endorse.
Who's
Are you
DUI?
endorsing, Mr. Woodnick?
There's, at the protective order hearing, mother listed 4 physicians that she claimed she was treating her current pregnancy for.
Okay, and I don't want to disclose those today in the hearing because I'm not sure
See,
who I
she's
have.
whispering. If you guys remember at that last hearing, she listed and named 4 doctors. The specialty doctor for the epilepsy that you have to show labs that you're pregnant in order even to make an appointment with. She listed those 4 providers. We want the records from them. Yep, she brought it all herself, J13.
I love that for.
Yeah, because look how quickly she goes to her counsel. They're not going to find anything with those doctors.
her current pregnancy for.
Okay, and I don't want to disclose those today in the hearing because I'm not sure who I have here virtually, but can the parties send a joint email to the court with the names of those doctors? And so that
Jeez.
I have a record of it, we will not put it in the minute entry because that is public. We'll just have the minute entry reflect, Lamar, that the court will be provided with 4 additional providers. But
I think it's 4. Don't hold me to that.
And Your Honor, I think it'll be more. Just to be clear, I believe it may have been 4 then, but we'll figure out the list.
Yeah, there's
All right.
a lot more.
We'll just have the minute entry cross out 4 and put more than 1. All right. So we've discussed disclosure, we've discussed the deposition, we've discussed all the pending motions. Mr. Woodnick, since this was your motion, is there anything you feel that the court has failed to address?
I think today was very productive. Thank you, Judge.
Thank you, Mr. Keith. Anything the court's failed to address?
I agree, Your Honor. Thank you for the court's time.
You're welcome. All right, everyone, we will stand in recess until June. All rise. Oh, counsel, you can come get these back if you want them. You might want to shred them.
So look how flat she is there. Look, she looked over at him. God, if he said, Laura, run away with me now, she would in a heartbeat. She would in a heartbeat.
You're right.
It's just a damn shame she thought she could get away with it.
She remember last week. Anything.
I was like, who am I to tell her?
She's trying so hard not to spell him.
You know what's funny is my Isabel's doing, not to that extent, but my Isabel memories. Sometimes I'm like, how in the world do you remember that?
Hang in your bag.
All right, guys, I'll be in touch. Thanks. Yeah, me too.
She's like,
Talk outside. We'll talk in the court before we.
yeah, we'll talk.
I love a hot bike.
Mhm.
Give me a hot bike.
We'll talk in the car. And she's small. She is a small, and that's going to be used, actually, Shay. How small she is going to be used to her advantage, or attempted to use to her advantage. No, Shay. I'm just like what Harlot said, though, like the likelihood for them to take perjury seriously. And when I say that, like for them to follow through on charges and indictments and a sentencing, like doesn't happen as often as you may think. And so I really hope, again, with her long history, it's not like a one and done situation with perjury. Like, no, she falsified medical documents and records and forgery and fraudulent schemes. Like, she did a lot. And
It's dangerous.
if it was a guy, Shay, if it was a guy who claimed, if it was the other way around, and it can't perfectly be the other way around, but like it would be taken seriously. And what I don't want is it to a slap on the wrist, because she's a girl. She's a small 90-pound girl. Like,
Yeah.
But what we have to go through is, like I said, the next is the trial. Like as far as like the next court hearing we'll be watching is the trial, and it's intense. It's very, very intense. And epic. It's amazing. But Shay also sent Laura's affidavits, and I'm very excited to go through that, because an affidavit, it's sworn under oath, like you're signing under penalty of perjury, and she is stating this is the truth. These are the facts. This is the truth. And so I'm so excited. Shay had sent me over 2 of them. So we got to go through those. But I really also want to go through the history of Greg Gillespie, just like we did with Mike, the Greg timeline. And I love that this page, The Victims of Laura Owens, I'll drop the link again. It includes screenshots, so you can actually see it. It's not just the timeline of being written. No, like, look, here's the references. Here it is, Victims of Laura Owens. So this is a bizarre one, guys. And I know I keep hearing about the other YouTubers that got involved, that she tried to harass and threaten them. And yeah, just bunny boiler wanting to be loved. What are your thoughts, Shay? Like, because I know we touched upon it a little bit ago, as far as it wasn't money, it wasn't necessarily fame. You know, like, what do you think when you're listening to all of this and seeing what she's done?
Honestly, I feel disturbed. I guess that's the only thing I can really describe it with, like, one word. It's disturbing. Um, and I feel sorry for her victims and even those that are unknown. Like, it makes cases where women are, like, searching for a partner to be active in a pregnancy, like, feel like it's a little standoffish, like, don't believe everything. And that sucks, because you see things like this. But I guess that's the way the world works. But it's disheartening because I think that a lot of people take the discussion of, like, say it's pregnancy or certain illnesses, they take that very seriously into heart. And it's like a precious thing that you try not to, like, be invasive of or denounce somebody of,
Right.
So it's tough. Oh, hold on one second. Michael. Yeah, 1 second.
And again, this is Mike Maricini, and his lovely wife and an adorable 2 little girls. It appears like $22,730 raised out of a $25,000 goal. That is absolutely amazing. And it says, "Thank you to everyone who has offered support, encouragement, and kind words. I truly appreciate it. I'm reaching out as I navigate a complex situation and begin exploring legal options. Any support, whether through a small donation or by sharing this page, will help defray out-of-pocket costs and allow me to get started with legal advice. I'm deeply grateful for any help during this time. Thank you for being part of my support system." So again, he is returning to court, I believe, at the end of this month. And Laura had successfully, from what I'm understanding, Laura had successfully obtained an RO against him back in 2020. And she filed to renew currently, so for like a lifetime order. And so this is him having to return back to court. But again, now that victims after him and everything's come out, it's really goes to show you, like, there's a major injustice that has been done. And so if you're interested, definitely go over, check it out, consider supporting. And I'm very curious what's going to happen at his, because, in court, it's not like you could just throw anything and everything out, but you can use and cite other cases. So I hope that'll work to his advantage and he has a good legal team and he'll be properly represented, because the fact that she can still pursue a restraining order, knowing what she's done to him and Greg and Clayton, it's insanity. Like, the nerve. You're facing 7 indictments, felony indictments, and you're like, you know what? Let me refile for this restraining order because I can't let up.
Sad. It's an abuse of the justice system.
That's exactly. She's a vexatious litigant, and it's always just clearly worked out, and she's always managed to land on her feet, but not this time. Fingers crossed, not this time. So, like I said, all of the hearings we go over, I'm going to be uploading them on the channel without commentary. So for anybody who's interested in just watching them straight out without, I totally understand. I have to listen to it without commentary too, and then I commentate over it, or vice versa. But I cannot wait to go over the trial with you.
Me too.
I cannot wait, because I'm telling you, it was so intense, and I didn't even know a lot about it when I first watched it. Like I said, I stumbled upon it, and I didn't, now that I know the full, not even the full context, partial context, I'm like, no way. Like, it's crazy. So we will definitely continue this deep dive, and it's a shit show, girl. It's a shit show.
It is. And I'm sorry if I seemed off. I was just hyper focused on so many things. I'm like trying to catch it all. I'm like, oh my gosh, this is a lot.
It's a lot. That's why I think we need me and you will work on a spreadsheet, because I need to have these dates laid out in front of me so I can understand and we can refer back to it, so we can catch the lies more obviously, because we'll have that timeline to refer back to.
For sure. Well, I thank you for having me. I'm going to have to jump real quick because my daughter
I
just
know.
stopped by.
Okay, well, I love you and thank you so much for hanging out and doing this with us.
Love you. Bye, guys.
Love you. All right, guys. Thank you for hanging out. Sorry I wasn't able to come on, but you guys know, being members of the channel, I appreciate it more than you know. It's the best way to support the channel. So thank you that we did this members only Monday on a Tuesday, but thank you all for being here. Thank you if you are not a member and you're just watching and you're here and you're supporting. I appreciate you guys, everyone, all so much. So we will continue down this deep dive and I will see you guys at the next episode. So good night.